Welcome back, class. Let's talk today about the federal court system. The federal court system was established by Article 3 in the Constitution. Article 3 did a couple of simple things to get the ball rolling. It established the Supreme Court as our highest court, and it allowed Congress to create lower levels of court that would serve different roles in our judicial system. It also spelled out how jurisdiction would work. In other words, what type of cases would be heard by what courts. So let's explore some examples of jurisdiction so that you can tell the difference from one type of jurisdiction and the other. The first type of jurisdiction that I want you to understand is exclusive jurisdiction. And these are things that are spelled out as cases that can only be tried at the federal court level. There are a few specific things from real life that can only be reviewed and tried by federal courts. However, there are other areas that can be tried either by a federal court or by courts in the states, state-level courts. And this is what's referred to as concurrent jurisdiction. So you have exclusive jurisdiction, things that can only be tried at the federal court level, and concurrent jurisdiction, which are things that can be cases that can be tried either in the federal courts or in the state courts. There's also original jurisdiction, which is the authority of a court to hear a trial. In other words, hear a case for the first time. So the very first time someone's legal matter or issue comes to the court, and the court reviews the evidence to make a decision. That's original jurisdiction in the trial. The fourth type of jurisdiction here is appellate jurisdiction. This is where this concept of appeals comes in. In our judicial system, a person can appeal a decision of a court and essentially have that decision reviewed by a higher level of court. This higher level of court that's doing that appeal has appellate jurisdiction and therefore it has the power to review that lower court's decision. We have courts in our federal court system that utilize these different types of jurisdiction. Either exist to have trials, or to have appeals, or to do a little bit of both. So let's look at the different levels of court in the federal court system and figure out exactly what they do. The lowest level of federal court is the U.S. federal district courts, and these are where the trials happen. So when a federal case is brought to court, the trial is conducted at the federal district court where that case happened. These are original jurisdiction courts that are empowered to conduct trials, and they're spread out all around the country. You can see on the map on the right-hand side of your screen that certain states are divided up into districts with those yellow lines. And all states have at least one red dot, which marks where the federal court for that district or that state is located. So there are 94 of these, spread out all around the country in different parts. And these courts are there to conduct these federal trials. So if a federal case happens in that state or in that part of the state, the court that handles that case is the district court where that case took place. The judges that serve on these courts are picked by the president, they're nominated by the president, and approved by the Senate before they take their seat. One level up from the U.S. district courts are the U.S. Court of Appeal. These are appellate jurisdiction courts. So these are the courts that are reviewing trials conducted by lower level courts. And again, you can see there's some geography involved. Check out the map on the left side of your screen this time. The country is divided up into a number of circuits. Each one of those color-coded sections is a circuit. And so there's an appeals court system in each one of those circuits that handles the appeals for the trials that take place in those states. Check out Virginia. You'll notice that we are in Circuit 4. We share that circuit with several other neighboring states. every appeal in the federal court system that happens in that area is handled by the Fourth Circuit. We've got 12 regional circuits, all staffed by judges who are picked by the president, again, approved by the Senate, and they are handling the numerous appeals that come up in the court system at the federal level. At the top, you have the United States Supreme Court. The United States Supreme Court is the highest court in the country, and the most important when it comes to answering important constitutional questions or solving big issues with federal law. So we have 9 seats on the court. One judge, one justice on the Supreme Court is referred to as the Chief Justice, sort of the organizational leader of the group, and then there are 8 associate justices. And these justices are, again, it's like everybody else in terms of a federal judge, nominated by the president and approved by the Senate. The Supreme Court is unique in that it has both appellate jurisdiction and also some original jurisdiction. So there are some cases that will go straight to trial at the Supreme Court, but most of what the Supreme Court does is hearing appeals. And since the Supreme Court is the highest court in the country, it can hear appeals that work their way up through the federal court system as well as the state court system, and will make the final decision on a given case.